Good morning.
Good morning. My name is Bruce Inman. I'm an attorney here in Sacramento. I'm a licensed broker, but I'm here on my own capacity, not in capacity on behalf of the building industry. But something I want to point out that I think is worth noting, in all the discussions on Bureau real estate issues, you don't hear any discussion of consumers being harmed by broken subdivisions where developers promised and failed to deliver. And the reason you don't hear that is the Bureau's regulation and the Subdivided Lands Act process with new developments is actually working incredibly well for both the consumer and the developer. The one fundamental exception to that is staffing. The Bureau cannot staff nimbly, cannot adjust to the demands of the industry. New home construction accounts for 2.1 jobs per home, according to a report of the state of California. So here we have an industry that creates jobs. They are regulated by a bureau. You don't have subdividers in this room with pitchforks complaining. In fact, the industry, I don't even believe, is here today to say anything is wrong, because as a functional process, the Bureau has it right. They do a good job at regulating and protecting the consumer. You're not hearing from the public saying subdividers selling subdivided land in California have harmed the consumer, because they're doing a good job. What they're not being able to do is their job efficiently. Being stuck as a bureau has limited their ability to address and adjust to the process, to the needs. We just went through the biggest downturn in real estate in California's history, and yet you didn't hear, and in fact nothing in the paperwork today even talks about the subdivision public report process. Your focus is on licensees, recovery, nothing on the public report process. I respectfully would say, why? Because overall it's working. The industry has figured out how to deal with it. The consumers are not here complaining because they're not being harmed. But what is fundamentally a problem is that the Bureau cannot efficiently address the market changes going from maybe a 2009, 2010, 2011 housing economy to today's economy. The Bureau cannot quickly address that because they have to go through the department, get money from Department of Finance, or authorization from Department of Finance. If you could change anything from the subdivision process, give the commissioner the ability to promptly respond to the needs of the industry. So I could go on.
Thank you very much. And I know that the Bureau has a request in for personnel to do exactly what you're talking about.
I mean, the whole notion, but this is California. Housing is unique. Property is the biggest purchase a person will ever make in their entire life, is a home. And yet we decided to put the regulation of purchasing that new home in an umbrella that is part of a consumer affairs that deals with lots of other consumer issues. But this is the big one. And I kind of note that lawyers are not subject to DCA's jurisdiction. So there are exceptions, and I think housing is so fundamental in California, it ought to be part of an overall organization and not a bureau within a department.
Very good. Thank you very much for that. Appreciate it. Anyone else from the public? All right. Mr. Bell, thank you very much for your testimony and for being here, and thanks for having the good relationship that you do with the director and with DCA. It's refreshing and nice to hear. So we'll invite Jim Martin, Bureau Chief of the Bureau of Real Estate Appraisers, to join the director to provide an overview of the Bureau and discuss some related issues in the background paper. And just a little housekeeping. This will be the final presentation this morning, and then we will kind of recess until 1 o'clock, and we will be across the hall in 4203 at 1 o'clock, and we will reconvene the hearing at that time. So thank you, just to let everyone know where we will be and how the morning will play out. Very good. Mr. Martin, good morning. Welcome.
There's the on button. Thank you very much, Chairman Hill, Chairwoman Bonilla, distinguished members of this joint hearing, and committee staff. Thank you for having me here today. My name is James Martin, and I'm the Chief of the Bureau of Real Estate Appraisers. And I've served in that capacity since July of 2012. Appreciate this opportunity to represent the Bureau before you today. The Bureau's mission is public protection. We accomplish this by promoting a high level of professionalism in the appraisal industry through programs in licensing, education, and enforcement. The Bureau is also charged with contributing to the goals of the federal mandate, which is to ensure the public's trust in the real estate appraisal industry. In 1989, Title 11 of the Federal Financial Institutions Reform, Recovery, and Enforcement Act was adopted by Congress. That act mandated that states license and certify real estate appraisers to appraise property for federally related transactions. The federal law was enacted as a result of the savings and loan disaster in the 1980s. In response to the federal mandate, the Real Estate Appraisers Licensing and Certification Law was enacted by the California legislature in 1990. The Bureau was established and charged with developing and implementing a real estate appraiser licensing program in compliance with the federal mandate. The Bureau currently oversees more than 11,000 licensed appraisers, 275 registered appraisal management companies, which we call AMCs for an abbreviation, and 80 education course providers. The licensing division in the Bureau is responsible for applicant compliance with the minimum requirements for licensure in accordance with criteria established by the Federal Appraisal Foundation and California law. The licensing division also registers AMCs in compliance with California law. The Bureau's enforcement division investigates the background of applicants, licensees, and AMCs in order to ensure that they meet the standards for licensure, and investigates complaints filed against licensees and AMCs. The Bureau is also responsible for approval of education courses and currently has more than 800 pre-licensing and continuing education courses approved. The Bureau has 33 permanent positions supported by the Real Estate Appraisers Licensing Fund. This fund is supported by licensing and registration fees. There have been several changes since the Bureau last came up for review. At that time, the Bureau was an office under the former Business, Transportation, and Housing Agency. Now the Bureau is under the Department of Consumer Affairs as a result of the Governor's reorganization plan in 2012. During the last sunset review, most complaints took over a year to close. Now there are only a handful of complex cases over 1 year old. Also, since the review, the Bureau has launched its IT system in 2012, and it has been working well. The Bureau has improved its website with the ability to file a complaint online and look up a license history of any licensee in California. The Bureau also has updated its strategic plan and is currently on course to meet its objectives. Finally, the Bureau began publishing a quarterly newsletter for licensees and the public. Most recently, the federal regulatory agencies issued joint rulemaking on appraisal management companies. The Bureau is currently working to meet and exceed those new rules before the deadline of June 2018. I will now move on to the comments on the 3 areas of focus that identified by committee staff. First was the department reorganization. In 2012, when the Bureau was transferred to the department, the transition required a cultural change. The Bureau's needs were not fully understood or accounted for prior to the transition, and the Bureau had issues with delivery of services by the department. However, due to better communication, the relationship between the department and the Bureau has improved. And the department's delivery of services has also improved. While there are still inefficiencies in some administrative functions, the level of overall cooperation has improved over time. For its share of pro rata, the Bureau receives all of its administrative services, including human resources, budget, fiscal, legislative, contracts, procurement, travel, training, business services, publications. The committee has identified that pro rata has doubled since fiscal year 2013-14. From discussions with the department, my understanding is that during the reorganization, due to the transition of services, we paid less. Our current rate now follows the same methodology that other programs follow. I will have to defer to the department for any more detailed questions on that subject. Regarding forces influencing value, as it relates to the appraisal management companies, the Bureau requires them to register and obey all Bureau laws. The Bureau regularly receives complaints that AMCs exercise undue influence over appraisers, and we investigate these complaints accordingly. The Bureau is not aware of kickbacks or gifts given between AMCs and lenders, as the Bureau only has authority over the appraiser's relationship with the AMC, not the relationship between the AMC and the lender. That oversight falls to the federal regulators and is not within the purview of the Bureau. The Bureau cannot substantiate whether appraisers are forced out of the profession because of unfair practices by the appraisal management companies. I believe the primary reason for the large number of appraisers leaving the profession is the significant decline in the volume of mortgage originations and the overall real estate activity across the country since 2008. The proliferation of appraisal management companies has had an impact on the distribution of work and on the delivery process of the appraisal reports. AMC appraisal work does make up a majority of the residential work in the market. So the AMC's business practices do have an impact on appraisers, which is why complaints of violations of law are investigated by the Bureau. Regarding standards of conduct, the committee has asked me to address broadening the list of appropriate appraisal standards necessary to complete non-federally related transactions. This issue was raised last year, and the Bureau considered the impact of whether or not licensees should be allowed to perform appraisals according to an alternative, nationally or internationally recognized standard for non-federally related appraisals. Currently, all licensees must meet the standards set forth in the Uniform Standards of Professional Appraisal Practice for all of their work. The Uniform Standards are the only federally created and approved standard, and federal law requires all appraisals prepared for federally related transactions to follow the minimum uniform standards requirements. Therefore, the issue is whether to allow alternative standards of practice for non-federally related transactions. Although the Bureau does not have a position on this proposal, it is my view that the impacts on the profession, the Bureau, and consumers could be significant. My first priority would be to make sure that whatever standard might be adopted would not put consumers at risk. The Bureau's mission is to protect the public, so any proposed alternative appraisal standard would need to be carefully evaluated to ensure the public is adequately protected. In addition, the Bureau would likely incur administrative costs due to the necessity of creating regulations and ongoing training to make sure investigative staff are adequately trained in a newly adopted standard. I appreciate the opportunity to discuss the Bureau with you today, and I'm happy to answer questions you may have.
Thank you, Mr. Martin. Just a couple of questions, if I could, and just following up and kind of getting a little more into that relationship between you and the department. You indicated that the pro rata has increased or doubled. I mean, we just heard that similar story and the problems with that. Do you feel that you're getting your money's worth?
That's a hard call for me to make. I came in July, August I started in 2012. Within about 6 months, the handoff had already begun. BT&H was sort of phasing out, and DCA was sort of picking up. So we started having meetings. So I didn't have a whole lot of experience, frankly, with the previous situation. I know that my previous administrative duties were being handled by the Department of Real Estate actually. I was contracting out for their services. They sort of had folded me into their administrative processes. So their budget shop, their HR shop, their lead shop, fiscal, everything, they handled that work for me. So that work was, as I said, within about 6 or 7 months of me taking over, as I was just sort of becoming familiar with the program and learning my job and learning the whole situation, all of a sudden there we were in meetings for the handoff. So the handoff came pretty closely behind my start. So I don't have a lot to compare to.
Okay. Do you remember what the cost, the pro rata was before when you were with the?
We were paying approximately $125,000 for our basic service. That didn't include the IT services. I believe the IT, we paid a lump sum of $250,000, I believe, in the 09-10 fiscal year for to have our setup sort of built within their IT.
And what are you paying now?
$482,000, I believe, is the number for the 15-16 fiscal year.
Okay, thank you. And are you comfortable in the relationship? I mean, is it working satisfactorily? Yeah, I know you were here for the previous discussion. Are things working all right?
Yeah, well, like I think I said
the
in
dollars, the monies, and you did.
In my testimony, I think it's always a big job to move into a department and fold yourself into it.
Right.
We're in some ways different than other bureaus, and so I have a little bit of the round hole and a square peg there too. The federal mandate, I have a lot of oversight from the federal government, and while there's there are still issues, some of the same issues that the commissioner mentioned, contracts and regulations. The communication's better. I feel like I have the ability to raise an issue that will be taken seriously, and so things have improved. Yes.
They have. Oh, that's good to hear. And just a final question related to the forces influencing value, the AMCs. You indicated that you do get complaints related to that. How have you pursued those, and what has been the general outcome to some? I'm sure it varies, but.
Okay, well, I can tell you that the three most common causes for discipline with AMCs is the improper influencing of the development of the appraisal. It's the pressure applied to the appraiser, so to speak, to sort of bring that opinion of value in favorably to one side or the other. Mm-hmm. Also, failure to have reasonable procedures in place to ensure that the appraisals are completed according to those uniform standards that I mentioned. Mm-hmm. Part of our law is that appraisal management companies have to pay attention to the work that's coming in. As they pass it through to their client, they need to make sure that it's done right according to the standards. So some AMCs we've found don't have proper procedures in place for that. And then also acting as an appraisal management company without being registered. That's the top three.
It's interesting. I mean, this is kind of a new phenomenon. I mean, over the last number of years, I mean, not that long, the AMCs and the active use of those. Do you find that there has been, and the purpose of them was to create a better product or a more honest product, a more accurate product, I guess, at the end of the day, and one that was not influenced in one way or the other. Do you feel that that has been successful in doing that, or because of the complaints and what you've observed, has it been a greater problem?
I don't believe it's greater. The idea was to put someone between, or an entity between the borrower and the lender. We have complaints. I hear it from the appraisers that I talk to. We don't get a lot of complaints, though. Less than 10% of our overall complaint volume is regarding AMCs. it didn't change the world as far as the position that the role that the appraiser's in. The appraisers always had the role of being between, you know, two parties in a business transaction. And if that appraisal goes one way or another, that there's an opportunity there for somebody to sort of want to apply pressure to that appraiser. That's just the role the appraiser plays. That's his job, and that hasn't changed. The advent of the AMC proliferation didn't change that. It's still there, and it will probably always be there. That's because that's what the appraiser. That's the position the appraiser is put in.
So you've not seen anything that would indicate that maybe this is a bad system that we've adopted or gotten into?
It's a
or that it needs to
federally
be
mandated.
changed or improved?
It's a federal mandate. I mean, we take disciplinary action against AMCs. We fine them. We've published on our website infractions. We've also done cease and desist orders. When we have cases moving right now through our process regarding appraisal management companies. So the appraisal management company also facilitates banking, the business of banking. A lot of the large banks, they want appraisal management companies to be there so that they don't have to do that function. They can sort of contract out for the panel management and the passing of appraisal work through the system. So it's bigger than, it's a national situation, yeah. But we do everything we can to investigate any complaint that comes in. We do hear about it. It's sometimes it's a documentation thing. An appraiser will feel like he's been mistreated or treated unfairly, but he has nothing to support that. There's nothing in writing, no evidence per se.
No emails.
And so we're out there trying our best. We do have, the new AMC rulemaking that came down from the federal regulatory agencies. So over the next year or so, when we start working on that legislation, we'll have an opportunity to sort of open that up and see what we can do to make the system better.
Very good. Thank you, Mr. Morton. Questions? Yes. Senator Bates.
Senator Hall, I'm not sure if this has been answered, but just looking at the pro rata cost increase, I didn't hear the explanation of why that has doubled almost since, 2013 or 2014, 2013, 14, and if it's redundant, could you just repeat it so I have it for my notes, because it seems to be appearing in all of these reviews, and I think we need to get to bottom of that if we're going to be talking about fee increases.
Sure.
In subsequent legislation.
With regard to Senator, with regard to Mr. Martin's bureau as well as the previous bureau, Commissioner Bell stated, there was, through the transition pursuant to GRP2, one of the strategies that was employed to aid in the transition as we figured out each other's cultures, where we can glean efficiencies, improve communications, as was stated, we wanted to decrease pro rata during that period of time, as reflected in that sheet that you have. Now that the transition is over, the formula that is normally used to calculate pro rata based on size, usage, et cetera, there's many formulas that calculate pro rata. That is now being applied, which is why you're seeing that steep increase. That is alarming, but I do want to assure this body that it is going from a artificial floor to what it normally should be based on many factors: size, usage, allocated positions, et cetera. So going back to what I said, the lower number was an artificial number to aid in transition pursuant to GRP2.
I think going forward, as we're going to contemplate this in future legislation over the next several months, that there really needs to be more detail, I guess, from the individual bureaus as to how this is benefiting their operation. And I don't get that feeling in the testimony of a number of them. So I'm just saying it would be very helpful to us as we're reviewing that to have that broken down in more specifics as to how it's working better and why the floor was so low. Therefore, I would assume if it was lower, that there were inefficiencies and then the data wasn't accurate, and a lot of the things that they're supposed to be doing was not being done well, or was not being tracked well, and licensees were not being served well. But when you have something that has to do totally with operations and administration of Department of Consumer Affairs, as it's relating to these individual entities, and their costs are going up, which means they have to pass that on to their licensees, there's a disconnect, at least for me, in terms of how I would evaluate a fee increase.
Thank you, Senator Bates. Seeing no further questions, opportunity for the public to comment on the Bureau of Real Estate Appraisers. Mr. Willett, good morning. Good afternoon. No, it's morning still.
It
Good
is,
morning,
barely,
Mr. Willett.
and I'll be brief, Mr. Chair, and Madam Chair is not here. I wanted to put a little context into some of the remarks that Mr. Martin made about the issue of alternative standards and why, on behalf of the Appraisal Institute, my client, this is such a fundamental issue that needs to be addressed collaboratively with BREA and with the Department of Consumer Affairs, because it relates to the number of licensees that we have now and we're likely to have in the future. Recall that Mr. Martin said the fundamental bedrock of our licensing law relates to federally related transactions. The federal law requires licensing and certification of appraisers only for federally related transactions. And essentially, although people disagree about exactly what that means, remarkably, essentially that means lending on residential properties. Now that is a relatively fixed pie of work, and it's changing dramatically. The AMCs that Mr. Martin and you have commented about changed it a lot. Technology has changed it. We're now doing appraisals with technology, with computer programs. So there will be, in our judgment, fewer and fewer appraisers necessary to do this work. What is happening is that the growth in appraisal is occurring on non-federally related transactions. And the way our law is structured, anyone can do those. So if it is non-FRT, I could do it, you could do it, and speaking for myself only, I would be incompetent to do it, and you wouldn't want me doing it. But anyone in California can perform an appraisal on non-federally related transactions. So we don't know who's doing that work. We do know that if you are a licensee, you must comply with the uniform standards of professional appraisal practice. And we believe that there are elements of those standards which do not work well for these non-federally related transactions where the growth is. So litigation support, if you're going to be an expert witness in court, if you're going to do financial analysis for large financial institutions, not in connection with making a loan, portfolio review, international work where people are coming in wanting adherence to international standards other than the uniform standards of professional appraisal practice. Our view then, and again, we want to work collaboratively with the Bureau and the Department on this AB 624, which passed both Business and Professions Committees, but is in the Appropriations Committee in the Senate, is that it is fundamental that you allow for recognized standards on non-federally related transactions only, because so-called USPAP doesn't work well. And it's actually creating a disincentive then to get a license. Because if you get a license, you've got to conform to USPAP, and that's not what the clients want. So going forward, the growth, we think, is going to be in non-federally related transactions, and you ought to want to know who's doing that work. So there is a problem in the law that we think needs to be addressed, and that's why we are the sponsor of that bill.
Mr. Chairman, I'm Stan Wade with the California Association of Realtors. We do not have a dog in the fight of alternate standards for appraisal practice, but I did want to give you a little context about the creation of the regulator. CAR was the sponsor of Mr. Hannigan's bill that set up the Office of Real Estate Appraisers, and we sponsored that legislation because we were facing a federal mandate that was going to disallow loans out of California if somebody didn't sponsor legislation to regulate appraisers. And the appraisal regulator has gradually seen his authority eroded by actions at the federal level that nibble away at their authority and impose more and more restrictions on how they regulate appraisers. But one thing we did in the original legislation was to limit it to federally related transactions. First, that was the loans that we saw that our members were most concerned about. But secondly, that was the limits of the federal mandate. They didn't have the authority to tell California, Mr. Martin and Mr. Kidani, what to do on the other kinds of opinions of value. So just to give you context, they do have the authority to move freely within that part of the arena. The other issue that I wanted to raise with you is that appraisal management companies have been very controversial. CAR-sponsored legislation that Mr. Hall carried for us some time ago that would have required them to be licensed by the department. They're registered now, but they're really, I don't think the department, while they're and I applaud them being aggressive, they don't quite have the same authority over AMCs that they would over the licensees themselves.
That's very interesting. I wasn't aware of that licensing and the lack of, so that's very informative. Thank you very much for the testimony. Anyone else care to address the committees, joint committees? See no one. Anything else, Mr. Bullock? Thank you. Very good. Well, we will, if there aren't any other questions or comments, thank you, Mr. Martin. Appreciate the testimony today on that. And we will recess now until 1 o'clock in room 4203, which is just across the hall. Thank you very much.